Thank you very much for being here. I wanted to have a press conference in order to clarify the record about the hearings that were had on Wednesday of this week regarding the March 21st riot cases. The hearing involved a plea to the jurisdiction and a finding by the judge that the procedures that were used were that moved the cases from a grand jury in a district court to a county court were not properly filed. I want to make this clear because it's been suggested that somehow it was a loss for our office, for the district attorney's office, and that's not a correct assumption or assertion. This is not a procedure that the district attorney's office or any prosecutorial entity has any control over. The procedure going from grand jury and moving a case from the district court grand jury to a county court is not a procedure that the district attorney's office or any prosecutorial entity has any control over. This is a process between the district courts and the county courts. Judge Morales felt that that procedure was flawed, and he took issue with it. And he, in taking issue with it, believed that the procedure was not appropriate, that he did not have, the cases were improperly transferred from the district court grand jury to his county court, despite an assignment order from the presiding misdemeanor judge. Despite all of that, he felt that it was improperly assigned to his court. Because of that, he dismissed those cases. Our office feels very strongly that the procedure was proper, that the district court, the district clerks, and the county clerks, the procedure that they used was all appropriate and proper. We argued that it was appropriate and proper, and we feel that very strongly, and we feel that it was done appropriately and that his order is an improper order. We have intentions of appealing his order to the Court of Appeals. There are already 2 cases out of the Dallas Court of Appeals that we feel are on point and that say that the way that the courts transfer the cases from the grand jury in a district court to the Court of Appeals was appropriate and done appropriately, and that his order dismissing the cases is inappropriate. It is not a good order. Because of that, and because we feel that the law is on our side, we have every intention of appealing his dismissal orders. Second, I would like to address some of the comments made by the El Paso County Public Defender. Ms. Childress and all of her employees are county employees. They are paid by the taxpayers of our community. It is important to understand that the public defender, who only represents between 40 to 50% of these cases. When the cases come in through magistration, the public defender's office is appointed to 40 to 50% of the cases. The private bar is then appointed to the other 50 to 60% of cases. Yet, inexplicably, Ms. Childress and her office have been filing 100% of the motions on these cases. They started off by filing writs. They go in and file their writs on a Friday afternoon, and in talking with the judge without us present, without any consultation with our office, filing these writs on a Friday afternoon and getting hearings on Monday morning. On Sunday evening, we have gotten notice that there's a hearing on Monday morning. A hearing for cases that are not, we have no notice of, we have no service on the application for the writ, and yet we have still shown up Monday morning with very little notice, not legally sufficient notice in our opinion, and no idea of what we're showing up for other than it's a hearing titled a writ hearing. But the applications were never provided to us. Then they continued this procedure with last Friday filing a series of pleas to the jurisdiction on a Friday afternoon with a hearing set for Monday. The judge, Morales, did actually continue those hearings set from Monday to Wednesday, at our insistence that our office be given notice and appropriate time to have adequate time to prepare for the hearings. But again, today he called us up to court with no notice and had additional hearings on the pleas to the jurisdiction made by one of the private defense bar attorneys, again without notice, without application of, without an actual copy of the motion being served on us. So again, our office is being called to court without adequate notice, without proper documents being served on us. Focusing again on the Public Defender's Office, they also have started to serve our office with Public Information Act requests, again using taxpayer money for these requests. They are requesting information from our office for information that has absolutely nothing to do with defending their clients and determining whether their clients are guilty or not guilty of the offenses that our office has charged them with. I am not sure what their agenda is, if it is political or what their agenda is, but they are certainly using taxpayer money to do things that are clearly not related to defending their clients on whether or not their clients are guilty or not guilty. And I question whether or not and why they are able to get hearings and taking us to court without providing us with adequate notice or without providing us adequate copies and service on the documents that they intend to have hearings on. Ms. Childress said that she wants to know, she's heard me say numerous times what these cases are not about. These cases are not about immigration. These cases are not about politics. She wants to know what these cases are about. I will tell you what I have said again and again. These cases are very clearly about law and order. If someone breaks the law in this community, this office, the Office of the District Attorney, is charged with enforcing the laws. And if someone breaks the laws in our community, we will file charges and make sure that that person faces justice in our courtrooms. It is our job to see that justice is done. And that means making sure that people who break the law are held accountable. It does not matter a person's immigration status. It does not matter if they are from this country or not. If you break the laws of the state of Texas, in particular in these riot cases, if you destroy property and you endanger lives, you will be held accountable. We will do our job, which is you will file those charges and take you to court and hold you accountable. It is not about immigration. It is not about politics. It is about law and order. It is about protecting our community. Thank you. I'll take questions. I must have done a really good press conference to have no questions. Yes, sir.
You mentioned that these cases are about law and order. Do you have a number as to how many cases might be, backlogged to pursue, these misdemeanor riot cases?
My office has been working, the intake division has been working very hard and working overtime hours to make sure that we are not neglecting other cases. Ms. Childress has said that she is shocked that we were able to file these misdemeanors as quickly as we have. We are under an obligation under the law with Class B misdemeanors. If a person is in jail, we have to file those cases within 15 days of a person's arrest. We have no choice. If we don't file it within 15 days, the person gets released out of jail. It is our office's practical policy to make sure that those cases are filed, misdemeanor Class B policies, files to be filed as soon as possible. And again, we only have 15 days before they're going to be released out of jail. So Class B misdemeanors in particular, we file those very, very quickly. The riot cases that we filed are all being filed as Class B misdemeanors.
And why is the DA's office filing indictments on with the grand jury instead of filing misdemeanor information?
In particular with Judge Morales, we know that there have been, going back, okay, we know that the magistrate judges are finding probable cause when they're being booked into jail. And then we know that Judge Morales is believing there is no probable cause based on the exact same complaint affidavit. Then we feel that it's proper to take those cases to a grand jury of 12 people in our community and ask those 12 people in our community, what do they think? If there's, whether there's probable cause or not. The grand jury is not limited to the complaint affidavit. The grand jury can look at the entire case. A judge is just looking at the complaint affidavit, the four corners of